So the three-masted Spanish galleon, the San Jose, sank in battle in 1708 off Baru Island, just south of Cartagena, which is now Colombia, laden with gold, silver, and emeralds. The vessel has never been salvaged. Treasures within the shipwreck are estimated today to be worth 17 billion. At the time of the sinking, Cartagena was part of the Spanish colonial empire under what is referred to as the Viceroyalty of Peru. At this time, the Viceroyalty of Peru covered nearly all of South America to the Atlantic coast in the southeast to the Pacific coast in the west, an area of 9.5 million square miles. The San Jose was sunk during the Spanish War of Succession, a conflict which arose from the disputed succession to the Spanish throne following the death of the childless Charles II, the last in line of the Spanish Habsburgs. His grandson Philip, a Bourbon, was nominated to the throne and became Philip V. Other European powers concerned over the grandizement of Bourbon power formed the Grand Alliance, which included the Habsburg Empire, England, and the Netherlands, later Bavaria and Portugal, and they declared war on the Bourbon states. The San Jose and its sister ship, the San Joaquin, were part of a Spanish treasure fleet during the war under General Jose Fernandez de Santillan, the Count of Castle Alegre. Prior to the loading of both ships, significant undertakings had been made by the Viceroy of Peru, Don Manuel de Oms de Santa Pau, first Marquis de Casteldosrias, to raise revenues for Philip V. The war in Europe had soaked up extraordinary sums, and Louis XIV and France had insisted he be paid quickly for the assistance he was providing to his grandson in Spain. So much of the treasure was amassed at the Portobello Fair. Portobello had become a central trading post for goods in South America. In the Portobello Fair, merchants would exchange silver and gold from the rich mines of the Viceroyalty of Peru for goods brought from Europe. Representatives of the Spanish crown would also collect taxes at the fair. At the end of the fair, Castle Alegre prepared his galleons to return to Cartagena, overseeing the lading of the king's revenue in money and other treasure. The San Jose and the San Joaquin, as the largest ships, carried nearly all of the treasure. In addition to registered treasure, a sizable amount of unregistered treasure was likely to have been carried on board. Almost within sight of the Boca Chica, the entrance to Cartagena's harbour, the Spanish fleet encountered an English squadron under Commodore Charles Wager, which had left Port Royal in Jamaica sometime in the early part of May by the Spanish calendar. The English ships had been patrolling the entire coast since early March, in anticipation of the galleons returning from Portobello, and the Spanish knew this. It was their intention to intercept and capture the Spanish galleons. And you can see from the maps here the kind of route that was taken between the two. Hopefully you can see that anyway. I know it's quite small, and you can see Boca Chica in relation to Cartagena. During the battle, as night fell, it was clear that the San Jose was in trouble. One witness discussed that by 9:30 at night, a great fire had broken out on the San Jose. It's not clear whether this was caused by the English or as a result of the cannons backfiring and causing a series of events. The other ships had difficulty seeing the San Jose, but after some time they were unable to see it. It had sunk. The ships were at the time Spanish ships were quite sort of spread out at this particular time. They were quite a distance from one another. It was unclear whether it sunk because a fire had burned through the hull or because of an explosion, presumably of the powder magazine. Accounts are disputed, but English sources say the Spanish flagship blew up, although the Spanish sources suggest that they could not hear an explosion. In any case, the San Jose disappeared and took with it Captain General Casalegre, all of his officers and passengers, and nearly all of his crew. Estimates range from anything between 575 to 650 men, and several English sources suggest that 7 to 17 crew members survived. So what happens to the wreck of the San Jose has become an issue of international arbitration. And it's been a court case that's been going on since the 1980s, or there's been various court cases, I should say, been going on since the 1980s concerning the San Jose, largely due to the fact that it's likely to include within it the biggest treasure trove ever to be been found in the shipwrecked ship. So first, at present, it's in front of the International Court of Arbitration at The Hague, and the first legal dispute concerns a private company, the Sea Search Armada, and Colombia itself. But before that, I just wanted to actually discuss some of the legal framework regarding this. So the protection of cultural heritage is a matter of interest in international law. Article 303 of the UN Convention on the Law of the Sea provides that states have the duty to protect objects of an archaeological and historical nature found at sea and shall cooperate for that purpose. And Simon Levis actually discussed this earlier as well. The Convention on the Protection of the Underwater Cultural Heritage was signed with UNESCO, and it includes all traces of human existence having a cultural, historical, or archaeological character which have been partially or totally underwater, periodically, or continuous for at least 100 years. These exist, but Colombia, and it's suggested because of the San Jose, is not a signatory to any of these treaties. So as I said, subject to legal dispute is the private company Sea Search Armada and Colombia itself. So the dispute between SSA and Colombia has been ongoing since the 1980s. Colombia had given permission to the Glockamora company, over which rights were then ceded to SSA to search for the shipwreck. When SSA announced the discovery, according to Colombian law, 50% should have been given to the state, 50% should have been given to the finder. However, 2 years later, the law was amended in such a way so that SSA would only receive 5%, and later legal cases disputed these issues. In 2007, the Colombia Supreme Court ruled that Colombia holds the rights to items deemed to be natural cultural patrimony, and anything else beyond what is considered to be natural cultural patrimony will have between the US salvage company, SSA, and Colombia, and determination of what is national cultural patrimony or not will have to be decided by independent experts. And to be honest, I don't quite know a great deal about what would be deemed to be cultural patrimony in this particular instance. There's also a number of procedural type issues in relation to this. Colombia claimed that SSA have breached the statute of limitations in relation to taking the court to the Permanent Court of Arbitration. They also dispute that Glockamora ever found the ship, which is germane to having an entitlement to it based on coordinates securely logged. SSA claim that the coordinates refer to a dispersal area, so it wouldn't be the exact, place where maybe the hull would be or something along those lines. Colombia has stated that they have found the ship and have released videos, although SSA argue that they were not entitled to do that under a previous agreement. Again, a procedural issue. Colombia also claims that the basis of the complaint, the US-Colombia Trade Promotion Agreement, came out after events and therefore cannot be the basis of a retroactive complaint. And the United States have actually intervened and have documents in the actual case concerning this around how that would be interpreted. So they have kind of a sort of periphery role here. Spain is currently a non-disputing party, but has sought leave to intervene in the arbitration, stating that there is, sorry, I'll just change slides. There is a legal dispute between the Kingdom of Spain and the Republic of Colombia over the ownership of the remains of the galleon San Jose. Spain contends that it has never abandoned its rights under international law as the flag state of the San Jose. So it basically still claims ownership of the San Jose as the flag state of the vessel. And they basically say then it's for them, their property, in other words, the Kingdom of Spain's property, and accordingly, San Jose and its remains are public property of the Spanish state. They are Spanish underwater cultural heritage and therefore within the legal nature of public domain, according to Spanish domestic legislation. They also have an argument about the exact location of the wreck, and they say it's still not to be determined, and that could lead to the ultimate resolution being in favour of Spain. According to Spain, Colombia publicly maintains that the rights to the San Jose are in its territorial sea, but there are serious doubts about the exact location, which may or not in whole or in part be in the Colombian contiguous zone. And the contiguous zone is an area of the sea where Colombia would have extraction rights, and there is some international law which looks at whether states have archaeological rights within the contiguous zone, but it's not fully settled. So this is, I guess, the basis of this particular argument. And again, that's something, I guess, when I hopefully look at this a bit later, when the actual full case comes out, I'll be able to look at it a bit more in depth. And then the event says Spain, independently of the exact location of the wreck, it's all still Spanish public property. But they also say that the San Jose is an archaeological site that should be respected as a war grave. According to Spain, its intervention in the arbitration is vital as it could establish that Colombia, the respondent, is not in fact the owner, which in turn means that not only could the arbitral claim be dismissed, but the tribunal itself may even lack jurisdiction to hear the dispute. So they want leave to intervene, access all the relevant documents, and work out who is the owner of the galleon. So at the minute we have a private company, Colombia, and the Spanish state, with a slight periphery interest from the United States. However, and this is what is of interest to me primarily, there is Indigenous peoples' claims as well. So to understand the claim of the Indigenous people, it's necessary to understand the context in which treasures such as gold and silver was extracted in Peru. Upper Peru was where the most important gold and silver mines in South America were located. These are specifically the mines of Potosi, discovered in the mid-16th century, located on the lands of the Caracara people. Journalist Nelson Freddy Padilla, in his book The San Jose and Other Treasures, explains that tons and tons of precious minerals taken from the mountains of Potosi were carried across the Pacific Ocean to Panama and transported in the backs of mules to Portobello, from where the San Jose departed for Cartagena. To extract the minerals, the Spanish crown used slaves, including black people brought from Africa and indigenous people. The indigenous slaves forced to dig up the treasure were the Karanga, Chicha, and Calaca peoples. In a letter to UNESCO, the Karanga, Chicha, and Calaca people have stated that Colombia's plans to lift remains without consulting their descendants would violate international law. The memory of our people is attached to those remains that rest on those sunken ships in the way that we do not choose as one of the peoples who gave their work and their own history to work in the mines of Cerro Rico de Potosi. Zenobia Fernando Rios, authority of Indigenous Justice Originaria of the Caracara people, has as well explained to El Espectador, which is a Colombian newspaper, that his claim is an historical vindication, not only because of the deaths caused by colonization. For example, 1 out of every 10 people who work in Potosi, out of every 10 people, only 3 survived, but also because of the disrespect that meant that the Spanish, strangers to their history, came to America to desecrate the tombs of our ancestors who were buried with all of their honorifics, since gold, the sun, and silver, the moon, had a spiritual significance. In the time of the Inca, of our ancestors, that was sacred, and the king ordered that the tombs be desecrated. He argued that it would be going against our ancestors, against our history, since for them the galleon, rather than representing wealth, meant ending human lives, humiliation, deculturalization of the entire American continent, peoples dispossessed of their lands and disappeared. And his hope is that if Colombia declares the resources that are submerged along with the San Jose galleon as heritage assets, they should serve to make reparations for the peoples who have suffered in America. And that means not prioritizing market value. I'm getting towards the end here, but Alina Perez Alvaro has argued that international treaties regarding the rights of Indigenous people are largely neglected in state-centric treaties, such as the Law of the Sea. The Law of the Sea itself consistently references states, for example. Most Indigenous people openly challenge the conventional system of state frontiers, including international maritime boundaries. The notion that Colombia as a state has rights over treasure of a wreck which may or not be in a contiguous zone from a time of history it did not exist as a state may seem odd from an onlooker, but particularly so for Indigenous people who do not recognize current boundaries. As argued by Perez Alvaro, the concepts state of cultural origin and state of historical origin are not easily applicable to the civilizations prior to the arrival of the Spanish or to Indigenous communities of any kind. And She highlights a similar case. So in March 2007, the Odyssey Marine Corporation discovered the shipwreck Nuestra Senora de las Mercedes with a treasure worth approximately 500 million in silver and gold coins. And these coins were mined again through the exploitation of indigenous people in Peru. And after the discovery of the wreck by Odyssey, which is a private company, the Spanish government decided to take a legal battle against the company in the United States courts. And in 2012, the US courts ruled in favor of the Spanish state, but any rights of the indigenous people in respect of this were basically ignored. She argues it is not just that there is no translation into their main language, but also that the interpretation of these Western-orientated legal instruments is very confusing for these communities because they do not have the same traditions, concerns, or solutions as the West. However, indigenous communities should have the right not to have those laws not only to have those laws translated into their own language, but to be participants in the drafts of these international treaties in order to choose their own path of development when preserving their own culture. So my conclusion is that this is obviously a very complex case. There is no settled concepts of who owns the San Jose, and there's going to be various legal disputes around whether it's in a particular zone in the sea, whether who discovered it, whether the coordinates are accurate, whether there's all these procedural sort of aspects that have been met and everything else. But it also identifies that Spain still has this colonial notion of ownership for something which dates back to 1708. Colombia didn't exist as a state at the time, but is claiming ownership over it because of their own colonial, or their own history and of independence, I should say. And there's very little, if any, consideration given to the rights of indigenous people who were the ones that actually mined the treasure that's on board, or at least a lot of the treasure that's on board. It could be argued that law is arguably unexpectedly absent in cases such as this, but in respect of indigenous peoples, I would suggest that it's probably expectantly absent because we know that international law is very state-centric and usually doesn't take into proper account those peoples that don't conform with Westphalian notions of state sovereignty, for example. Within the context of the seabed as an unexpected place, colonial histories of ownership appear to be out of date when considering who owns the rights to shipwreck treasure or what should be done with it. And a concluding remark is there's no easy solution to a case such as this, but at least we should be given consideration to the rights of indigenous peoples. If indeed really any is actually required, because what we're talking about here effectively is a grave, and the treasure within it has been obtained through enslavement and death of indigenous people. Should it be the case that we leave it and the shipwreck continues to rest on the seabed? Thank you.